none other than Carl Reynolds and BJ Survant from Reynolds, Horne Survant. And we're talking about catastrophic injuries and wrongful deaths, a very serious, serious topic because they generally don't end well or they have life-altering circumstances that go along with them. But we do have some questions. And our question tonight comes from Jonas, and he wants to know that he's heard someplace that some states put a cap on the amount of money that you can win in a lawsuit. Is that true? And if it is true, what if the amount of your damages are so much more than the amount that's allowed? So who wants to tackle that one first? I mean,
well, there was a time in Georgia when we had a cap in medical malpractice. Our General Assembly, in its infinite wisdom, set the cap on wrongful death or non-economic damages, and later the Supreme Court struck it down. So right now there is no cap on non-economic damages in Georgia. We've had several cases in North Carolina. There is a cap in North Carolina of $500,000 on any wrongful death case arising out of medical negligence. But BJ, you might want to address the history of was it Senate Bill 3 in Georgia?
It was, yeah. Yeah, it was, it's been a while now, but yeah, they enacted what they call tort reform. And one of the provisions of tort reform was to make it supposedly more attractive to businesses to come to Georgia because they're getting rid of all the damages that people could recover in lawsuits. As Carl mentioned, the part of that was a cap on the damages as to pain and suffering, that sort of thing. And that the Supreme Court struck that down as a violation of the Constitution. So like you said, there isn't a cap on anything there now. There's still a cap as to punitive damages. It's kind of a weird cap because it's paid a certain way. And there's no cap if the damages are based on alcohol or drug use. But that's the only cap I'm familiar with here in Georgia. Other states, Carl mentioned North Carolina, I think Florida's got somewhat of a cap in med-mal. I'm not certain what it is. And a lot of neighboring states have different limits on pain and suffering or wrongful death or other limitations on damages. But the question also mentioned, what happens if your damages are far worse or more than that? And sadly, there's not much you can do if there's a valid statutory cap. You can't go over that.
Well, let me ask this question. Let me throw it to both of you. What's the big difference between, say, a $10,000 or $100,000 case and $1 million case? Because if you were to listen to some of the commercials, you will really think that you can get a lot more, or you're insulted if you get a lower amount.
If I start on that, I don't know when I'll finish.
I was about to say the same thing. It's just, there's a lot of things that go into the value of the case. The one thing that should never enter the value of the case is what somebody on TV says the case might have brought, because you don't know anything about it. The lawyer might say, we got $500,000, well, the case might have been worth $10 million. You don't know, so it might just sound like a lot of money, but it's actually pennies for what they should have gotten.
Yeah, so, there's an old joke in the plaintiff's bar that you know how to get $1 million settlement. You start out with a $3 to $5 million case. Now, here's the reality of that joke, and it comes sadly to a lot of people who are in this situation. If you have a $3 million case, you're going to probably have to investigate it, file a lawsuit, go through all the discovery, go up to the point that you are ready to try the case and actually try the case. In some instances, you might try the case twice. We had a med-mal case one time that we tried. The first time we got $1.7 million, $1.8 million, and the Court of Appeals overturned it on the basis of one of the jurors' answers to a voir dire question. So it came back and we tried it a second time. The second time we got a similar amount and it went up again. No. On the second occasion, one of the jurors who was a wino, we had several strikes on both sides, and both sides felt like this man would not be a factor in the consideration at the end of the trial. We were wrong. Both sides were wrong. We tried the case. The jury went out. This fella, they said, well, let's just see what everybody thinks and take a straw poll. And everybody write down whether or not the defense is liable and what you think the case is worth, et cetera. And this fellow just turned around, put his feet up on the windowsill and looked out the window and said, I don't have to do a damn thing. So the next day, after they'd been out for 4 or 5 hours, the judge called us in. He'd gotten, I think, 4 or 5 letters from the jurors saying this man was a nut job and would not participate. Well, by this time, the defense kind of got they sensed that they were going to get hit again. So they could have agreed to take a verdict from a jury of 11, but the defense counsel wouldn't. So we go back a third time and try the case. And we got a verdict that was similar to the verdict in the first case. And that case was finally put to rest. But we tried the case 3 times. That's a true story. That happens.